So thank you for joining us today. We are going to now officially start the webinar. And before I introduce myself and our presenter, I would like to acknowledge that Jessica and I are on Gadigal land today, and we pay our respects to elders past and present. Because we are doing a legal education session, I also like to acknowledge that Aboriginal people are the first and continuing storytellers and educators on this land. So thank you very much for joining us today. My name is Natalie. I'll be facilitating this session today, asking questions, keeping an eye on the questions, putting those to Jessica. I'm from the Community Legal Education branch at Legal Aid, and we are very lucky here to have our subject matter expert on this topic, Jessica, who's going to be talking about some changes to the law for people on temporary visas experiencing domestic and family violence. So I think it will be very interesting, and we will all learn a lot about what's new and what's changed in the law. And before I hand over to Jessica, you've probably heard this in other legal education sessions, that what we are talking about is really legal information. It's an overview of these new laws, the immigration law concepts. It's not legal advice. Each situation is different, but we will certainly tell you where you can go to get that specific legal advice for your clients. So thank you. I am going to hand over to Jessica now. Thank you very much.
Thanks, Natalie. Good afternoon, everyone. My name is Jessica Shulman, and I'm a senior solicitor in the immigration team at Legal Aid. I've been working as an immigration lawyer and specifically with women on temporary visas experiencing or at risk of domestic and family violence for about 13 years. Last year, there were a lot of changes to the family violence provisions, and this has had a really major impact on the options available for women on temporary visas who experience family violence in Australia. So in this session, I'll be trying to cover quite a lot. First, I just want to speak about Legal Aid and specifically the role of the immigration team and what we do here. I'll be reviewing the family violence provisions and the other exceptions, child of relationship and death of sponsor. And I'll be taking us through the eligibility criteria and changes to these exceptions. I'll also be going through what evidence needs to be collected to make a claim of family violence and how that claim can be supported. And importantly, I'll also be covering when the exceptions don't apply to temporary visa holders and what options might be available in those circumstances. Next slide, please, Natalie. Thanks. So the immigration team at Legal Aid is a free legal service that advises and represents on immigration and citizenship matters for New South Wales residents. Legal Aid New South Wales provides free legal advice to everyone in New South Wales. A person doesn't have to be a citizen or a permanent resident to get legal advice from Legal Aid. On the screen, you can see some of the services that we provide to clients and what we can give advice about. Now, everything that people tell legal aid lawyers is confidential. So that means that we can't tell anyone what our clients say or give us unless our clients agree. Sometimes legal aid helps more than one person in the same case. So we have lots of lawyers. So one of our lawyers may help one person, for example, the wife, and another legal aid lawyer may also help the person they have a dispute with, for example, their husband. In this scenario, both the wife and the husband could receive advice from different legal aid lawyers. Sometimes people think that legal aid can't help both people if a matter goes to court. That's not the case. Both parties can still apply for grants of legal aid. Legal Aid actually has a panel of private lawyers who can help in these situations. And any information about eligibility for grants of legal aid is available on the Legal Aid New South Wales website. So when might you refer to the immigration team at Legal Aid? Well, you probably refer to us when you've got a client on a visa and something's gone wrong, or when you think something's gone wrong. So, for example, where a client's circumstances has changed, their relationship has ended, they've gotten into trouble with the law, where a client has experienced domestic or family violence. when a client tells you that they don't know what kind of visa they hold or if they even hold one at all, where there's been a decision on a visa or where they've been asked for more. It's so important not to delay making a referral, especially if there's a deadline or if a client doesn't hold a visa. And I think while it goes without saying, getting advice about a legal matter doesn't mean the client has to act on that advice or take the advice if they don't want to. Sometimes it's just enough for someone to know the family violence provisions are there as a safety net for them if they ultimately choose to leave down the track. Getting advice is about finding out about your options, and whether a client decides to act on that is really up to them entirely. Many clients receive advice and then they return months later ready to act. It's also incredibly important for a person to get legal advice first before they contact immigration. There are serious ramifications to advising of a change in circumstance, the information to provide immigration, and the next steps are all important factors that a client should fully know about before they decide to take that step. Immigration have recently made it quite easy to advise of a change in circumstance, but it is my strong view that before that happens, if possible, everyone should speak to a lawyer. We're also really lucky in the team to have a senior caseworker with a social work qualifications and background working with our team to provide psychosocial and practical support for vulnerable clients. Now, towards the end of the session is where I'll provide you with our contact information and how to make a referral.
Thanks, Jess. I'm not sure if you noticed, but some people have know how to use the thumbs up, and they were giving you a thumbs up that yes, good to
Good
get
to know.
legal advice first.
100%.
Yeah.
Now, around 40% of the work that we do in the immigration team is related to domestic and family violence. And it's around 40% of women on temporary visas in Australia that have actually experienced domestic and family violence, with coercive control being the most common kind of domestic and family violence that they experience. Now, since the 1st of July 2024, coercive control is a criminal offence in New South Wales. And this new offence captures things like repeated patterns of physical or non-physical abuse used to hurt, scare, intimidate, threaten, or control someone. Threatening to cancel a person's visa as a means to intimidate, threaten, or control someone absolutely fits this definition. And we see this a lot. Threats to cancel a person's visa if they call the police or tell anyone about the family violence. It's important to know that while the sponsor of a visa application can withdraw sponsorship, their right to do that, they can't cancel a person's visa. They also can't force someone to leave the country. This is called exit trafficking, and it's also a crime. While the sponsor for the visa can withdraw sponsorship, only the Department of Immigration decides whether the visa application is withdrawn or refused. And they won't do either of those things without giving the visa applicant an opportunity to tell their side of the story and determine whether they are still eligible for the visa despite the withdrawal of sponsorship or change in their circumstance. So this is why it's so important that the visa applicant has control over their visa application. They know where their correspondence is going, and the Department of Immigration has their current contact details. So I'm going to talk about the 3 exceptions to a relationship breakdown. Just on the next slide, Natalie. Now, until recently, these exceptions were limited to partner visa pathway applicants, and they are the family violence provisions, the child of relationship provisions, and the death of sponsor provisions. Now, these 3 exceptions have been around for about 2 decades. The purpose of them was to provide a safety net for some applicants on a permanent residency pathway. Specifically, the policy purpose of the family violence provisions was to ensure victim survivors of family violence didn't have to remain in a violent relationship in order to continue their permanent residency pathway. Presumably, child of relationship provisions were inserted in order to keep children in Australia connected with their two parents. And I'll speak briefly about this exception and death of sponsor exception later, but we're going to focus on the family violence provisions first. Natalie, I'm just wondering, are there any questions before I
Um,
move on?
just one more about who you provide advice to. So do you provide legal advice to people irrespective of their visa status?
Yes,
Yeah.
that's correct. We generally advise the person on the visa. We don't generally advise the sponsors, the Australian citizens or the permanent residents that are sponsoring. It would generally be the temporary visa holder, the visa applicant that
Yeah.
we would be advising. But if you're not sure, you can always refer and we can let you know.
And you mentioned before you also advise people who are not on a visa.
Correct,
Oh,
that's right,
yeah.
yes.
Okay. Next slide then.
So this is the definition of family violence and it's set out in the migration regulations. It's defined as conduct, whether actual or threatened, towards the applicant or a dependent of the applicant or their property that causes them to reasonably fear for or to be reasonably apprehensive about their well-being or their safety. Now, I'm sure you can already see this definition is very different to that in family law. The reference to relevant family violence actually refers to family violence that has occurred during the relationship. So for immigration purposes, only family violence that happened during the relationship is relevant. Any family violence that happens after the relationship ended isn't relevant for the assessment of the family violence provisions. Now, I'm sure we're all very aware that the most dangerous time for a victim survivor is when they leave a relationship. A lot of family violence happens after they leave and often continues for some time. Now, this evidence can provide context to the family violence, but it can't be relied on solely to satisfy the family violence provisions. In some circumstances where an AVO is applied for on the basis of a family violence incident which occurred after the relationship ended, you'd want to review the provisional AVO and the facts and see whether these cover more than one incident, including any incidents that happened during the relationship. And that's quite common. And if it does, then it can usually be relied upon. It's always really important to have all this evidence checked by an immigration lawyer before providing it to immigration. Now, you can also see in this definition examples of the types of family violence are not included. It's really very open to any conduct which is actual or threatened as long as it causes the victim to reasonably fear for their well-being or safety. It's going to meet the definition. So I guess what I'm trying to say here is it's not just limited to physical violence.
Do you mind if I ask a couple of questions?
Sure, Natalie.
Is it counted as coercive control if it's the victim of domestic violence who's wanting to withdraw the sponsorship from an abusive partner? I think, were you going to talk later about if the sponsor is the perpetrator or
I
if
am.
the,
We're really speaking here about um, family violence where the perpetrator is the sponsor. We're going to speak about family violence where the perpetrator is the primary applicant because the family violence
yes.
provisions have been expanded to include certain or other visas where the primary applicant is the perpetrator rather than an Australian sponsor. I hope maybe after I've spoken about that, perhaps that might answer the question.
Yes, yes, that does sound like it. And also, I think I understand this question to be if there's a visa application and the only contact details on that application are the perpetrator's contact details, how does that work? Or am I misunderstanding that question? Maybe the person can reword it if I haven't asked that question correctly.
It is often the case that there is, one authorized recipient. One person is receiving correspondence for a visa application, and it might be a sponsor, it might be a migration agent or a lawyer. Sometimes it's not the visa applicant. When if the relationship breaks down and there's been domestic violence, that it is really important for the Department of Home Affairs Immigration to have the visa applicant's contact details. That is something that we would advise on. We'd advise on how you could do that. We are in the process of developing some resources about some really practical things on a range of topics. We hope to have them out in the next few months.
And just to clarify, we've called this session Women on Temporary Visas, but the laws apply in same-sex relationships and in any situation for any
Absolutely.
genders. Yeah.
I do want to acknowledge, while family violence can happen to anyone regardless of gender or sex, it is overwhelmingly a gendered issue. And I do acknowledge that we see family violence perpetrated in non-heterosexual relationships. We also see family violence perpetrated by women towards men. All of my case studies and examples are about family violence perpetrated by men against women. That is overwhelmingly the reality of the situation faced by our clients, but it is, of course, it is family violence perpetrated one person to another. It's not gendered language, as you can see in the definition of family violence. It's not gendered language.
Great. Thanks, Jess.
Okay, so just before we move on, I do just want to quickly run through some terminology I'll be using for the rest of the webinar. I think sometimes immigration lawyers, we forget, or lawyers in general, we forget that we use a lot of terminology people may not really be able to follow. So that's why I wanted to provide this slide. So when I talk about on and offshore applications, this refers to where the visa applicant is located at the time they make the visa application. So partner visas have an onshore and an offshore equivalent. So it's where the visa applicant is at the time that they lodge the application. They pay, the $9,000 odd for the partner visa, will determine whether it's an onshore application in Australia or offshore outside Australia. Partner visa pathway is just really shorthand for a group of visas that require an Australian or permanent resident to sponsor their spouse or de facto or fiance partner from overseas. So this is where we have an Australian-based, permanent resident-based person who is sponsoring someone from overseas that they're in a relationship with. When we talk about time of application, this is the date the visa was made. The application fee was paid. It was all filed and lodged with the Department of Immigration. And when we talk about time of decision, this is the date the visa application was decided one way or the other. Primary applicant refers to the person that satisfies the primary criteria for the visa. So for example, it will be the person with the skill set or the qualifications needed to make an application for a work or skilled visa. Secondary applicants are the dependents of the primary applicant. So usually their family, their wife or husband or their kids. Okay. Next slide, please, Natalie. So up until July 2024, the family violence provisions were only accessible to applicants on a partner visa pathway. And even then, there were a lot of limitations. So for example, a fiance visa holder could only access the family violence provisions if they married their sponsor first before the relationship broke down. This really limited the access to this pathway. Another example was that the family violence provisions didn't apply to offshore partner visa applicants unless the temporary partner visa was granted and they arrived on shore. They could only then make a claim of family violence if they experienced that family violence after arriving on shore on that temporary partner visa. So they couldn't rely on family violence that occurred outside Australia before the visa grant. Other limitations were there were strict location requirements for where a visa applicant had to be at the time of decision. So if an applicant lodged their partner visa application in Australia, they had to be in Australia at the time of decision, and vice versa for offshore applicants. And this really affected a lot of applicants who wanted to go home to get some support while waiting for the outcome of their onshore partner visa application. It also meant that any offshore partner visa applicants who had travelled to Australia temporarily on a visitor visa, for example, to visit their partner while they waited for their partner visa to be granted, they couldn't access the family violence provisions if their relationship broke down while they were here in Australia and they experienced family violence. Okay, so before July 2024, lots of caveats, lots of limitations on the family violence provisions. So we're going to look at the changes now to the family violence provisions that have happened in July 2024. So firstly, access to the family violence provisions has been significantly expanded. So I think we've gone maybe one too far. There we go. Thanks, Natalie. Okay, so now prospective marriage visa holders can access the family violence provisions even if they didn't marry the sponsor first. That's a pretty big deal. Access to the family violence provisions has also been expanded in circumstances where an offshore partner visa applicant has experienced family violence on or offshore, as long as they've entered Australia at any time for any period of time since lodging the visa application. So this would cover an applicant who's come to Australia maybe for a short visit on a visitor visa and where the relationship has broken down and they've experienced family violence in Australia. There's also been a relaxing of the strict location requirements for time of decision, or where the applicant has to be at the time of the grant of the visa. Fiancé visa applicants can be onshore at the time of decision, as can offshore partner visa applicants, and onshore visa applicants can be offshore at the time of grant. And this has been actually incredibly helpful. We've actually assisted a number of applicants who experienced domestic violence, family violence in Australia. And while they wait for their claim of family violence to be assessed, they've actually travelled overseas, to be with family. And this is now possible for them to do so. So they go home and they can recover with family somewhere where they're comfortable and they feel safe. It's been a big game changer. Next slide, please. So in October 2024, and again in December 2024, the Department of Immigration announced 2 further expansions to the family violence provisions. The family violence provisions now apply to 17 further visa subclasses, including business, skilled, and family stream visas. You can see them all here on the screen. The definition is the same. There are, however, some major differences as to how the family violence provisions apply to these new visas. Next slide, please, Natalie.
I might just ask a couple of the questions that have come through, which might be relevant to types of visa holders.
Sure.
Someone has asked if a temporary visa holder is anyone holding and this might be my ignorance, but a BV, does that mean a bridging visa?
Yeah, sure. So
BV.
anyone holding a bridging visa, I would qualify as a temporary visa holder. Yep.
And if somebody is here as an international student who experienced family violence in Australia,
Generally student visas are temporary visas. I do speak briefly about student visas in some slides that are coming. You can see, however, student visas are not on this list. They're not on the list of the 17 further visa subclasses. All of these visas that you can see on the screen are all permanent pathways to Australia. So these are all permanent visas that people might apply for. A student visa is not a permanent visa. So the family violence provisions will not apply to a student visa, unfortunately.
But we will give you at the end some referrals for where those people can go for help. And
we do give advice to women on temporary visas where the family violence provisions do not apply to them. For example, people on student visas.
Yeah. And in general, our domestic violence unit at Legal Aid can talk to people no matter their visa status or anything like that. So yes,
absolutely.
But today we're specifically talking about these
Right
family
now,
violence provisions.
that's right. Yep, right now we are. Okay, so when we're talking about the 17 further visa subclasses you just saw, um, some pretty major differences as to how the family violence provisions are applied to these new visas. So firstly, the victim survivor is not the primary applicant. They are the secondary applicants of the visa application. There's no Australian citizen or permanent resident perpetrating the family violence. So the perpetrator would be the primary applicant for example, the skilled visa or the business visa or the family visa, and the victim survivor is a dependent of the primary applicant. So everyone is a visa applicant. And this is very different, as you can imagine, to the partner visa pathway, where the perpetrator of the family violence is an Australian sponsor and the victim survivor is an applicant, a visa applicant. The victim survivor must be the spouse or de facto partner of the primary applicant at the time the visa application is made. The relationship must have ended. Either the partner or the children of the primary applicant must have experienced the family violence from the primary applicant, and everybody has to be on shore at the time of application or since the application was made. Probably the biggest difference between the partner visa pathway and the new expansions to the family violence provisions is that for the victim survivor to be granted the visa, first the visa has to be granted to the primary applicant or refused for reasons including the family violence related conduct. So for example, if the primary applicant's visa is refused for reasons including failing the character test because they've got a conviction relating to the family violence, then the victim survivor can still get the visa. But if the visa is refused to the primary applicant for a different reason, for example, they've failed to meet the skills criteria for the visa, then everyone is refused the visa. Could you go to, I think, slide 17? Yep, I've done that one. Thank you. So how does it work practically for a secondary applicant who has experienced family violence? They first need to disclose the change in their circumstance. This would be presumably the separation from the primary applicant and make a claim of family violence. I'm told there's a new form on the IMI account, which is created for this purpose. And once immigration is advised, they say they will split the application and process the application for the primary applicant and the victim survivor separately. Now, I've said this before, I'll say it again. It's so important for the victim survivor in this situation to get legal advice before they speak with immigration. Any questions, Natalie, before we move to the next slide?
There are a lot of questions. I'm trying to go through them all. So just relevant to what we've talked about recently, just clarifying the slide about, I think, the eligibility expansion to the different subclasses. Someone's asked if those expansions are relevant visas that the family violence provisions apply to. That's what you were talking about? Yep. Excellent. There are some other questions, I guess, generally about the cases of family violence a bit when it's, I guess, extended family members. The violence is from a member of the family, such as a mother-in-law, for example. How does that work for this situation?
It doesn't, unfortunately.
Mm.
No, the family, in order to access the family violence provisions, the alleged perpetrator must either be the sponsor of the visa, that's for partner visa applicants, or the primary applicant on the visa for the 17 new subclasses. Yeah.
Yeah. And someone was saying to clarify the earlier question, it's a situation when the primary visa holder is on a temporary visa and about to apply for permanent residence visa, but the partner, the dependent, has been abusive. Can the victim, female victim, take him off the visa as she is still, or is she still compelled to add him? Or is this
That's a
a
great
matter for legal
question.
advice?
And I think that person needs to get legal advice.
Okay.
Yep.
Yeah. There have been a couple of questions where I'm just saying, please refer your client to legal advice and we'll let you know how to do that. I think that
But
would
I
be
think it's really clear that it is a really complex area. We're still trying to find out how it's all going to work with these 17 visa subclasses. And yeah, I guess watch this space. But I think the most important thing to take away is that I guess before it was really sort of a very limited number of people could really access the family violence provisions. Now that's been really expanded. So keeping your eye out for people who are secondary applicants on these kinds of visas. And you don't have to remember these subclasses either. Just know that it's been expanded and it's possible that that visa subclass could be on the list and you can refer them for
Yep.
further advice.
And there have been some questions about evidence required for family violence. So that's what we'll get into in a bit.
We will
Yep.
definitely. We're going to go to a couple of case studies. These are all, of course, made up case studies, but they are reflective of the general experience of our clients. So this is Frances, and this reflects the changes to the family violence provisions for secondary applicants. So this is how presumably it would work. So Frances and her kids are secondary applicants on her husband Joseph's subclass 189 visa. The family are all onshore on bridging visas. They're awaiting for the 189 visa application to be granted or decided. One evening, Joseph physically assaults Frances and the police are called. An AVO is applied for. Common assault charges are laid against Joseph and the relationship is over. Now, Frances is referred to the immigration team for advice on her visa options, and she's really relieved to hear that she and her kids can continue being eligible for the 189 visa, even though the relationship between her and Joseph has ended. And it would be around this time that our team would assist Frances to advise the department of the change in her circumstances and that she and the kids have experienced family violence from Joseph. We assist Frances to open up her own IMI account and her application is split from Joseph's application. Now, Joseph is convicted of common assault and there's a final AVO granted protecting Frances and the kids from him. And Frances gives a copy of that AVO to immigration as judicial evidence of the family violence. The Department of Immigration will refuse Joseph the 189 visa because of his family violence offending. But despite this, Frances and the kids can still be granted that 189 visa. So I think that's a good case study of how this pathway would work for secondary applicants. Now let's look at a different situation. This is Situ. This example reflects the changes to the family violence provisions for someone on a partner visa pathway. So Situ is from India. She meets and marries Frank, who's an Australian citizen. They get married in India and they apply for an offshore partner visa. Now, Frank returns to Australia. Situ is packing up, waiting for the visa to be granted, but she misses Frank. So she applies for a visitor visa to travel to Australia and spend a bit of time with him while she waits for the visa to be processed. And she heard that the rules have changed. So her visa can be actually granted while she's in Australia. Soon after she arrives, Frank assaults Situ. Situ leaves Frank and reports him to the police and the relationship is over. So in the next slide, we're going to look at Situ's situation pre-July 2024 changes and now. Natalie, I think we've gone a bit too far.
Sorry.
Perfect. So before the changes to the family violence provisions, Situ's situation would be a real problem. As an offshore partner visa applicant, her visa can only be granted offshore. The family violence provisions would not apply to her. There'd be no pathway to continuing her visa application. Once her relationship with Frank had ended, her visa would be refused. But since July 2024, Situ's case can be granted while she's onshore. She can make a claim of family violence, and it can be considered while she's here onshore, or she can go back home and it can be considered from offshore. The only real problem that Situ would have is that she's not eligible for a bridging visa A or any bridging visa really associated with the partner visa because it is an offshore partner visa. So to remain lawful in Australia, she'd need to either apply for another visitor visa or apply for a bridging visa E. And it could take some months for the family violence claim to be assessed and determined. However, as we can see, things overall are much better for people in Situ's situation than they were before. Okay, so I'll back things up just a little. I want to touch on two things. First of all, in order to have a claim of family violence even assessed by immigration, immigration must be satisfied. The relationship between the perpetrator and the applicant was genuine and continuing. This requirement has to be satisfied at the time the visa was applied for and up until the breakdown of the relationship. Immigration will assess the bona fides of the relationship based on 4 factors: shared finances, nature of the household, social aspects of the relationship, and the nature of the commitment. Unless immigration is satisfied of the bona fides of the relationship, they will not move on to assess the claim of family violence and the visa will be refused. So we all know that victim survivors of family violence often flee with very little of their possessions. The family violence they may have experienced may be related to financial abuse or isolation, and so they may not have a lot of evidence about their shared finances or social interactions as a couple. Could I get the next? Yep, perfect, thank you. So in spite of this, there's still lots of really creative ways to collect evidence that both demonstrate a genuine relationship and also keep the victim survivor safe from the perpetrator. That's why the only real don't on this slide is contacting the perpetrator or any relative or friend who's going to put the victim survivor in danger.
Can I jump in? Sorry,
Mhm.
there was a question of whether the perpetrator of the violence is notified when the victim or survivor notifies the department of the abuse. So I guess this
It's a good
answers
question.
that. Yeah.
Yeah. So my understanding is that they are not. The perpetrator will receive a it's a template letter from the department basically saying that we're aware the relationship has broken down or that you are no longer sponsoring this person and you should be aware this person may still be able to get this visa. And that's it. They're not notified that the visa applicant has made a claim of family violence against them.
Good.
So some evidence a victim survivor can collect themselves without the perpetrator ever needing to know or find out are things like text message conversations. They're great. And the more boring, the better, in my view. Anything about picking up milk, who's going to feed the dog when they get home, that kind of stuff. Only people in a relationship would ever send text messages like that to each other. And social media posts and photos. Going through emails, you can contact a real estate agent to ask for a copy of a tenancy agreement or contact a bank or a utility company if they were joint account holders. I recently had a client take screenshots of deliveries that were sent to their joint household over the years. I thought that was really clever, evidence that they live together. And all this evidence should obviously be reviewed by a lawyer before it's lodged. Next slide, please, Natalie. So as long as the relationship evidence is accepted, immigration will then request evidence of the family violence. And a claim of family violence must be supported by either judicial or non-judicial evidence. And the most common judicial evidence that we see is a final AVO. Now, not all victim survivors report family violence to the police. Not all reports result in an AVO. So the other way a victim survivor can show they've experienced family violence is by preparing a statutory declaration and 2 documents from professionals on a prescribed list. Next slide, please.
And if people are not in New South Wales, AVOs have different names in other
They
states and
do.
territories.
So who can support a claim of family violence? The list is exhaustive. And when you look at this list, you might be of the view that there are some kind of professionals that are in fact missing from this list. For example, counsellors other than family relationship counsellors aren't on this list. And where we see this having an adverse impact is where a client has been receiving ongoing support from a counsellor from victim services, where that counsellor, you know, may not be able to support a claim of family violence because they're not on the list. Something else that's missing from this list is professionals registered overseas. So for example, where a victim survivor seeks treatment from a doctor overseas, that evidence won't meet the requirements because the doctor has to be registered in Australia. And the same for social workers and psychologists. And this, in my view, is a real gap in the system that needs review. Now, the evidence that we see most is letters from services that fall under the definition of a family violence support service provider. These include women's refuges, migrant and community resource centres, and specialist teams working within NGOs and charities who provide support for victim survivors. And in 2023, the requirements were loosened, and now social workers and psychologists can provide their evidence in the form of a letter or report, not just a stat dec. Risk assessments can also be approved from family violence support services and also from police, although I've never seen one. There is now much more flexibility in the format of the evidence. Hopefully that really makes the preparation of evidence more efficient and easier to obtain. So in the next slide, we're going to have a look at the content requirements for a social worker.
Before we move on, Jess, and I think you answered this question by saying this list is the list. You have to be on this list. If somebody has confined in a priest or a religious support worker, they wouldn't be able to provide the evidence.
But you would, they may be a religious support worker who is also a social worker or who works in a family violence support service. If you're not sure, have a chat with us. Give us a call.
Thanks.
Okay, so the content requirements are still really strict for most types of evidence to be accepted. This is just one example. This is for social workers, and their letters have to contain 3 things. It has to state that the victim has made a claim of family violence, has to state in their professional opinion whether the claim of the victim is consistent with them having been subject to family violence, and it has to identify the perpetrator or provide information from which the identity of the perpetrator can reasonably be inferred. Now, this requirement doesn't need a 5-page report. Usually, from what we see, a page to a page and a half will suffice in most circumstances. And these kinds of details, the kinds of details that give the letter or report weight are things like when the victim survivor engaged with your service, the length observed the family violence yourself to have a professional opinion as to whether the claims are consistent with them having been subject to family violence. Your professional opinion is based on factors like reporting, your observations of the client's behaviour and demeanour, their responses and reactions, and your own qualifications, skills and expertise as professionals working with victims of family violence. I know sometimes there's some apprehension and possibly some fear around providing evidence that will be used in a legal matter. Giving your professional opinion based on your observations and skill and experience will not get you into trouble. You won't be subpoenaed to give evidence. your letter or report is filed with the Department of Home Affairs, not the courts. A copy is not given to the perpetrator. The perpetrator doesn't get a copy to respond to. The letter is really for the sole purpose of supporting a claim of family violence. I would recommend any professional asked to provide evidence to support a claim of family violence who has any concerns about preparing a letter to speak with someone from our immigration team. There are no silly questions. Ultimately, we're all here for the same reasons, which is to support vulnerable people in difficult situations. And if we can do that by, answering your questions, then I think that's awesome. And we're always happy to discuss any concerns you might have about preparing or providing evidence to support a claim of family violence. And we are developing resources to assist and guide the drafting of this evidence. We really do expect to have these resources available on our website in the next few months. So really briefly, because I'm running out of time, as I didn't think I would, but I am. So the child of relationship provisions sit with the family violence provisions, and they still only apply to people on a partner visa pathway whose relationship has ended and where they have a child and they share some kind of obligation to the child with the sponsor. The one significant change that came about in July 2024 is that the child of relationship provisions now apply to fiancé visa holders applying for a partner visa. And generally, and I do mean very generally, a birth certificate with both parents declared will suffice to satisfy this provision. In the situation, if you've got a client in this situation, they should definitely get legal advice. Finally, we turn to death of the sponsor exception. And this is where the sponsor dies before the permanent partner visa is decided. Now, we don't see a lot of these cases, but the changes are really positive. So there are now, there's no requirement for the applicant to show they've developed close business, cultural, or personal ties in Australia. And I think, yeah, all of these sort of additional requirements are now a thing of the past. And all of these changes to the family violence provisions and the child of relationship and death of sponsor provisions really serve to make it really much simpler, easier, and hopefully less traumatizing for eligible visa applicants who've experienced upheaval and unexpected change to continue their permanent visa pathway. Now, we do have a way to go. I'm sure all of us have some really great ideas about how to make the exceptions even more accessible, and I'd love to hear anybody's thoughts on this. But for now, these changes are a fantastic step towards better, safer outcomes for vulnerable clients. So the next thing I want to talk about is what happens when the family violence provisions don't apply. And they don't apply to lots of temporary visa holders. Student visas, temporary work visas, visitor visas, none of these can access the family violence provisions. And of course, people that don't hold visas can't access the family violence provisions either. One of the most complex cohorts that we see is women on temporary or no visas with Australian children. And many of these women will have little to no option to remain long term. They may be going through the family or the criminal courts or both, and struggling to find a way to remain lawful, sometimes for years while they navigate these systems. And this is particularly problematic when a person's temporary or unlawful status is used as a way to control them. And we do see women unlawful for many years being promised a partner visa pathway by their Australian partners, but kept in an unlawful state and threatened with deportation if they speak out about their family violence. Now, you'll notice I've put 444 visa holders on this slide because they do technically miss out on the family violence provisions, but recently their status is considered permanent for the purpose of citizenship eligibility. So long-term 444 visa holders can actually become eligible for citizenship simply based on their status as a 444 visa holder in Australia. Next slide, please, Natalie. So the family violence provisions don't apply. What can we do? Immigration history is often the key to figuring out what options are available. And there are no two cases that are the same. So in these situations, any good immigration lawyer would explore all potential pathways, temporary and permanent. If the client is afraid to return to their home country, we would explore applying for a protection visa. If we think there are unique and exceptional circumstances, we might advise and perhaps assist with a strategic request to the Minister for Immigration. I think I talk about this in a little bit more detail in one of the next slides. So this is Mary's story. This is a really common example of the kind of situations that we see regularly. So Mary is on a student visa. She came 2 years ago, and last year she fell in love and moved in with Jack, an Australian citizen. They've just had a baby. Jack recently became abusive towards Mary, and Mary's fled with the baby. Her visa is about to expire. She can't apply. She can't afford a new student visa. She really wants to stay in Australia, but if she can't, she wants to go back to Vietnam with her baby. What can Mary do? I think Mary's options are really, really limited. Her student visa is about to expire. She can't afford a new one. Her child is Australian. It's not clear whether she can travel overseas with her baby without Jack's permission, and she really needs family law advice. She also needs advice about her options to remain on shore, but in my view, this is really limited. So in the next slide, I've got 3 possible options for her. So one thing she could do is she could write to the minister. This is not easy and it can take years. In order to write to the minister, you can't just write to the minister. You've got to apply for a visa, have it refused, both at the department stage and on review. That could take years. Only then can she write to the minister. She would have a bridging visa, but it might not come with work rights or with Medicare rights. And the minister intervenes very, very, very rarely. Another option, if she decides to seek orders from a family court for permission to travel with the baby, this could take years. To remain lawful, she may only be eligible for a bridging visa E, and again, maybe not get work rights or Medicare. She might not get the orders she wants in the end either. Finally, I always get asked about parent visas. Now, a parent visa requires an adult sponsor. Usually this is an adult child of the parent. A relative can stand in the shoes of the baby, but who's going to do this for Mary? So unless Mary is over the pension age, she won't be granted a bridging visa to wait out the processing time for the parent visa, which is between 7 and 35 years. That's conservative, depending on the type of parent visa she applies for. So as you can see, none of these are good options. Ultimately, when we reflect on women in Mary's situation, it is really clear that something needs to change in our system because we are letting these women down, and especially where they are the primary caregiver for the child and they've experienced family violence from the Australian parent. Now, I get asked a lot whether a temporary visa holder is eligible for Centrelink or temporary and public housing, and the answer is unfortunately no. So what is available in terms of support and for women on temporary visas who have experienced family violence and are facing homelessness and destitution? So firstly, I think we all know about the Red Cross Family and Domestic Violence Financial Assistance Program. That's a fantastic port of call, first port of call for any temporary visa holder experiencing DV. They can get up to $5,000. They can get referrals to specialist services and support coordination. I know that there are women's refuges across New South Wales who provide crisis accommodation for women on temporary visas with no income, but I also know these services are limited and the support that these women need outstrips the support these services are set up to provide. There's often no exit pathway for this cohort because they're not eligible for temporary housing or public housing. So it's a really fine balancing act. Finally, Medicare is available on most bridging visa A's and bridging visa C's where the applicant has applied for a permanent visa. If you have a client who's on a BVA or a BVC and they don't have Medicare, they might need to apply for it. They might need a condition removed from their visa, which might be quite simple to do. They might just not be eligible. It's a good idea to get advice. So finally, key points here. Early intervention is essential. Please don't wait to refer. This stuff is really complex. It has changed a lot in the last 12 to 18 months, and we're all wrapping our heads around it. And no 2 cases are the same. We really do believe that where a client can get professional advice about their options, no matter what their decision, they will be better placed to make the best decision for their unique circumstances. And there is no harm in getting confidential and tailored legal advice. And it is so important. I sound like a broken record. So important to get advice before contacting immigration. And that's what we're here for. So after all this, how do you contact the immigration team at Legal Aid? You can contact us directly on 02 9219 5790. You can email us. And I think we might pop this information in the email that we send people at the end of the day with a link to the webinar. And there are no wrong doors at Legal Aid. So if your client's getting family law advice from a legal aid lawyer, and they know a client is on a temp visa or no visa, they will internally refer to the immigration team. Law access is also an excellent pathway to the immigration team at Legal Aid. Natalie,
Thank you.
we might have a couple of minutes for a
Thank
few
you.
questions.
We do. I was just taking a deep breath. I think you've told us a lot about some changes that are quite positive, and there's also a lot of people who are quite concerned on this webinar about Mary and people in her situation, because there's still, yeah, it's really, really tough for
You are
people.
not the only ones. Yes.
Yeah. Okay, so we do have a few questions which we might try and go through, if that's all right. If people do need to, you are perfect with your timing, by the way. It's right on 1 o'clock. If people do need to leave, we understand that. You will be getting an email that will have a lot of the links that we've been talking about today and that you can see on your screen. There will also be a link to the recorded webinar. I'm just going to also put a plug in. A few people were asking questions about subpoenas, being a bit worried about being subpoenaed. So I'm giving a plug for a webinar we have coming up on the 10th of April, specifically for community workers for your organisations, and what to do if you have been subpoenaed. Because I think somebody's mentioned there could be a parallel domestic violence case going through court, for example. So there
Sure.
might be subpoenas in those cases. So that's what we're talking about on the 10th of April. So I'll put the link to that webinar in the email. So yes, just a plug for that.
Awesome.
Okay, so I think that answers a couple of the questions. Going back, I don't know if you remember the case study of Joseph. Someone was asking if he would have to return to his home country.
Um,
Do you want me to go
the
back to
focus
that?
isn't Joseph in that case
Yeah.
study, but presume if you don't have a visa pathway in Australia, then generally the option that you have is to return to your home country. Yes,
Yep.
to leave
Okay.
Australia. Joseph may have. It's also generally advisable for Joseph to go and get some legal advice as well.
Yes. Yes. Some questions about some creative questions about what Mary could do if she could go, maybe not to the Minister of Immigration, but a local MP in her area. I'm sure they get all sorts of questions like that. But
Yeah, I can see this this question here. Can Mary seek help from a local federal MP? She absolutely can. Um, but unless she's got a specific request before the Minister for Home Affairs, it's generally advisable to do that first and then get and attach a letter of support from the local federal MP. And I think, as I've made it really clear, it's quite a pathway. It's quite a journey to even get to writing to the Minister for Immigration. It can take years.
yeah. Gosh, as you can see, there are a lot of questions, Jess. I'm not sure.
There's a
I
lot
think
of
some
questions
people have,
around Social Security,
yeah,
which I think is someone else is probably better placed to give advice on those sorts of things. There might be one or two questions in here about temporary visa holders being granted Centrelink. To my knowledge, that's not the case. But if you've got some examples, I'd love to be proven wrong. Please prove me wrong.
yeah.
Um,
Some other schemes for people to access help, for a scheme for migration agents to be able to give advice. I mean, like Jessica mentioned, Law Access New South Wales is a great first point of call. I'll put that number in the email as well, but that's 1300 888 529, and they refer to community legal centres, all sorts of other services that might be available as well. So yeah, there would be other options for help. other more specific questions, we will go through those and we will try to answer those by email, or there will be some links in an email you get after the webinar. So with the recording, link to the recording, and also we will try to answer some of these questions. But I think because we are a little over time today, we will stop there. So thank you all for your participation, and thank you for joining us today. It was really valuable, Jessica, and we really appreciate your time and your expertise today. There's lots of little claps and hearts and things you can see coming on the screen now. So thanks, everyone. And we will
Thank
see
you,
you
everyone.
at the next webinar. There is a webinar next week. Jessica's colleague, Hannah, will be talking about the Administrative Review
Protection visas.
Tribunal, about protection visas,
She'll
yes.
be, yeah, it'll be on protection visas. It'll be really interesting. Please come along.
Thank you. Thanks, everyone.
Thanks,
Bye.
everyone.